Bloomberg Audio Studios.
Podcasts, radio, news.
You're listening to the Bloomberg Intelligence Podcast. Catch us live weekdays at 10 a.m. Eastern on Apple CarPlay and Android Auto with the Bloomberg Business app. Listen on demand wherever you get your podcasts or watch us live on YouTube.
Here we go, the breaking news from the Supreme Court. Supreme Court overturning a Chevron ruling, and this really is a blow to agency power. So this is truly about federal agencies and the current wide berth they have to interpret unclear laws. And it looks like the Supreme Court has now overturned that Chevron deference. Let's get to June Grasso right away. She covers Bloomberg legal analyst and host of the Bloomberg Law Show. June, we've been waiting for this. Walk us through what this means.
So the Chevron doctrine means, the legal definition of it basically is that if there is an ambiguous statute, an ambiguous law, then deference is given to the agency's interpretation. What it also means is basically, who has more power, the administrators at agencies or judges, experts in the area or judges who have to sort of learn as the cases go on. So we have been suspecting that this court was going to overturn Chevron because conservatives have for years been targeting it, and several of the justices, including Clarence Thomas, have been talking about overturning Chevron. What this means, and this case was just a case, actually it was two cases with the National Marine Fisheries where there's a rule that the fisheries have to have observers on the boats and they have to pay for those. And that was being challenged here. And so even though the fact is that they've never actually had to pay for those fines, but theoretically they do. So what the court is saying, and it's the chief wrote this, it's 6-3, again, second 6-3 decision in this case. And, we suspected that it would come out this way because of yesterday's opinion, knocking back the SEC and saying it can't have, in fraud cases, it can't have its in-house counsel. It has to be, people have to be able to go to the federal court and have a trial by jury. So we expected this, and anyone knows there are these people who say this is the, basically the end of the world kind of things. This means that federal agencies are going to, cut back on their regulations. Things are going to be challenged. They do things, all of the regulations, health and safety, consumer regulations, food and drug, that all these are going to be affected by this, and they will, but the question is how much, and that remains to be seen. So, and people on the other side say, well, no, it's not going to really have that much of an effect. We haven't been really using Chevron, and as I've said before, the Department of Labor has already stopped using Chevron as a reason for its regulations in light of this case coming down. So we just don't know what the effect will be, whether it will be huge. And also the Supreme Court hasn't really based any of its decisions on Chevron in a while, so who knows? But it is a blow to agency power, as you said in the first place.
Why do we call it the Chevron deference? Because like you said, this actual case at hand that the Supreme Court is making a ruling on right now didn't have anything to do with the actual company, Chevron. Well, it was just a precedence. Walk us through how we're understanding that.
With Supreme Court precedents, often the name of the case where it's decided is given the title. So Chevron deference comes from a case 4 decades ago involving Chevron. So that's why we call it Chevron deference. It has, that name has nothing really to do with the case, the fisheries case here. But that's the name it's had for 4 decades, and that's the way it's referred to. So, if you're in law school, that's what you're studying, the Chevron. Yeah. Chevron deference. It's Chevron document. It's called Chevron deference because you give deference to the agency's interpretation.
So does this mean, though, that it's going to be judges that are going to decide the laws versus experts within agencies that aren't elected that decide laws?
Well, that is the intention of the.
But what do judges know about interpreting?
Here. Well, what happens is judges, let's say, they'll learn. For example, you have antitrust cases, right? Judges do all kinds of complex cases. So you have antitrust cases, and they take evidence from both sides. They listen to all the experts, they study it, and then they come out with a ruling. I mean, the Supreme Court, are they experts in the areas that they've been? Homelessness, that's the way the judicial system works. You have judges who are supposedly independent and are independent, and they come to a decision based on the facts and based on weighing both sides of the arguments. But, it's going to make it more difficult for some agency regulations, and you can imagine that. And this was pushed by conservatives and business groups. They wanted to get rid of Chevron. So, and this is all about the war on the administrative state, how the 6 conservatives have sort of been bent on not taking down the administrative state, but certainly lessening the power of federal agencies. And as last year, there was a case involving the EPA and its control over water pollution. And the Supreme Court invented a doctrine called the Major Questions Doctrine so that they could take back some of the power that the EPA has there. So it's been going on for a while, but this has been sort of out there as a target of conservatives and business groups. So the impact is, who knows what the impact will really be.
So what exactly how do the businesses feel about this decision? What is the general argument of why the businesses want to overturn this?
Well, they think that agencies have too much power, basically. So they think that this is evening out the landscape, and it just will make businesses don't like restrictions, right? I mean, the SEC, that all that we were talking about yesterday was in-house. Whether you can have your proceeding in-house, judged by an administrative law judge who knows the area, securities lawyer who knows the area, versus being able to go to court and have it, a trial. So obviously, it's sort of the less restrictions on business, the better it is. So that's, I think, what and. So I haven't been able to read it because I've been talking. But,
But my question: how much of this do you think is about climate and the EPA and the really tough restrictions that have come down through the agencies on interpretations?
Excuse me. That's one sort of big area here, but it's not just climate that's going to be affected. It's
of course not, but was that really why conservatives were pushing this, or we're not totally clear?
Conservatives have been pushing this and what's funny is the Chevron doctrine was a conservative doctrine that was put out 40 years ago, and in time, conservatives have just, don't like it. They don't like the restrictions that it imposes, and so they have attacked it. But so it's just where you want less regulation. It's sort of, when Trump came in, remember, less regulation, that's one of his things. I took regulations away, and he had this big stack of regulations. So, and it, also, depending on the administration, whether or not regulations are being enforced more, what the regulations are. But this, will affect everything, workplace rules, every rule. And I think that what's going to happen is a lot of agencies are going to do what labor has been doing, which is not rely on that. Say, it doesn't rely on this. This is our agency power. It comes from our agency power. We don't have to go to the Chevron deference.
All right, June, thank you very much. I know we're not done with you yet. Stay tuned because you never know what else is coming out. June Grasso, Bloomberg Senior Legal Analyst, joining us. Let's continue the conversation here. Anthony Sabino is professor at St. John's University, Tobin College of Business. And as a reminder, we're looking at the Chevron deference has now been overturned. The Supreme Court throws out decades-old legal doctrine that empowered federal regulations to interpret unclear laws. Professor, thank you for joining us. We appreciate it. You've had some time to read through the opinions. Give us your takeaways here.
Yes, well, first of all, thank you for having me on this important day. This decision is the right decision. It's a very good decision because it honors both the Constitution in terms of its text and its constitutional plan. Now, no doubt we have heard, and we're going to hear a lot more of the wringing of hands and Sturm und Drang about this is the Supreme Court going off the rails, discarding stare decisis, upending agency power, and basically making life very difficult for the agencies. I respectfully disagree, and to use a word I've heard Mr. Biden use quite a lot recently, is that's a lot of malarkey. First of all, it's not a radical decision. It's true to the Constitution's text and to the constitutional plan. For the Supreme Court, for all judges, wherever they may be, their job description can be summed up in 2 words: judge is judge. Chevron diminished that. Okay, it required judges to defer to agencies, and it was keeping judges from doing their jobs, which is to independently, thoughtfully, and of course forthrightly use all their skills, all their wisdom to interpret the law. And as such, Chevron inflicted damage upon checks and balances and separation of powers. In fact, Chevron introduced an imbalance because it gave an advantage to the agencies, to the government side. And again, it's a zero-sum game. If you advantage one side, then by force of logic, you disadvantage the other. What this case now does, Loper Bright, is it levels the playing field. Now everyone comes into court, okay, and has the same situation. The agencies will still be able to advocate for their position. The public, okay, the American citizen, she will still be able to advocate for her position, and the court will listen to both sides, and we will take it from there. As such, now we will have that balance restored as the way it should be. Okay.
How should we understand what this means for businesses? We are Bloomberg. We do follow markets very closely. What's your take on the business implications of this decision?
Right. Hello? Yes. Okay. Right. I'm sorry.
Sorry, I'm zooming. I'm zooming in at the same time. Okay, but I'll stay on the phone with you. All right.
We got you. Can you hear us?
Yes.
Okay.
All right. Do you want me to stay on the phone or the computer?
This is a great question. I feel like the computer is just fine. All right, so let's get back to that question that Emily was asking in terms of what businesses sort of think about.
Well, businesses are going to obviously welcome this because it removes that unfair advantage. It is not in any way, shape, or form going to radically change how agencies do business. They still have all the enforcement tools available to them that they had previously. They're still going to be able to argue their position in court. They simply will no longer have that unfair advantage of coming in ahead of the game and already being able to basically tell federal judges, well, look, you don't have to apply your skills. You don't have to analyze these ambiguities in statutes. We're the experts. We will do that for you and just listen to us. And again, that violates separation of powers and checks and balances because you diminish the power of the judges to do the job that they're constitutionally bound to do. And you are expanding the power of the agencies, which are, of course, as we know, part of the executive branch, part of Article 2. So you elevate one branch over the other branch and prevent the other branch, the judiciary, from doing its job. Now, certainly businesses will benefit by having this, but also enforcement actions are going to go around. They're going to continue in the way they have in the past.
Going forward, do you think that laws will then be written with different kind of clarity then to prevent things being held up in courts? Like
exactly.
Okay, so
that's the whole point.
Right. So if that's the case, can you give me an example of something that might have been that might be rewritten or might be written differently now that the Chevron deference is by the wayside?
Okay, well, for example, and I heard you discussing this with June a couple of moments ago, is environmental laws and the regulations promulgated thereunder. Congress, and again, this shifts, if anything, shifts a burden slightly, or basically is a reminder to Congress that they need to do a better job. We have to remember that one of the reasons Chevron came about was that the Supreme Court at that time in 1984 said, all right, well, what do we do when there are ambiguities in the statute? Well, you have a statute that's ambiguous. You have an agency that promulgates a regulation or brings an enforcement action to enforce that statute, notwithstanding the ambiguity. And as such, the court at that time in Chevron said, well, let's listen to the experts, let's listen to the agencies. And that, again, at the time, Chevron was a good decision and rightly decided and worked. But it's been taken too far where now, again, the deference has gotten out of hand and it has increased the imbalance of the favoritism of the agency's view and also, again, basically shutting out, foreclosing judges from doing their job. Now, back to, again, as an example, environmental law, but it applies to securities law, antitrust law as well, because of all the controversy presently therein. It's going to compel Congress to write better laws to erase ambiguity, to iron out the ambiguities and the problems and the misconceptions in the words of the statute. So that way you have clear statutory text. Therefore, regulations promulgated by agencies will be just as clear because they're starting from the clear foundation of the statute itself. And enforcement actions in terms of what can be brought and what cannot be brought will likewise benefit from that same clarity. And judges, of course, will have an easier time because, as again, this Supreme Court has said, and the Supreme Court of 200 years has said, we go by the plain English meaning of a statute and we apply it according to its plain English text.
So in theory, though, in theory, businesses should have then more clarity, I think is what you're saying. Like if the law is written more clearly, then the business should say, okay, now I got it. What's the reality, though? Like, Congress can barely get, anything done. Are they really going to be able to write more clearly when it comes to certain laws, particularly confusing ones like climate or antitrust?
That's their job. That's what we, the people, elect them for. And if Congress cannot write laws with clarity, then it's up to we, the American people, to exercise our will at the ballot box and put in people who know how to write a clear, unambiguous statute. It's as simple as that. That's the constitutional plan. That's separation of powers. That's checks and balances. So Congress needs to get to work. And in the instances where Congress cannot be, as clear as one might like, the bottom line is that also reflects political compromise. Because yes, ambiguities arise in statutes because of the political compromise that is undertaken in the halls of Congress. And of course, with the president ultimately signing off and making it into law and so forth. So to that extent, that's a natural part of the process. That's democracy at its best. That's a Republican form of government at its best. All right. You're not always going to get perfectly clear statutes. Okay. But again, there's nothing wrong with Congress trying to do that. And if I may, as you say, businesses, but let me broaden that if you allow me. Okay. It's not just American businesses. It's all Americans. All Americans, individual in their personal lives, their personal liberties, business people, business persons, businesses as entities, we're all entitled to statutes that clearly state what the law is. So that way we can look at them and we know that the law is consistent. It's applied to everybody the same way. It's predictable. So when I decide I'm going to take a certain course of action, I know what the legal result is going to be. That's part of America. That's the way it should be. And once again, Local Bright today restores that balance by letting judges judge.
All right, Professor. We hope that plays out that way. Anthony Sabino, professor at St. John's University, Tobin College of Business. Just as a reminder to update you on this breaking news, the Supreme Court overturns a Chevron ruling in a blow to agency power, throwing out a four-decade-old legal doctrine that empowered federal regulators to interpret unclear laws. And now that goes to judges and then back to Congress to write very clear laws.
You're listening to the Bloomberg Intelligence Podcast. Catch us live weekdays at 10 a.m. Eastern on Apple CarPlay and Android Auto with the Bloomberg Business app. You can also listen live on Amazon Alexa from our flagship New York station. Just say, Alexa, play Bloomberg 1130.
Definitely the Supreme Court decision day. The latest is that Supreme Court backs the January 6th defendant, curbing the use of the Enron law. Remember, nearly 300 defendants, including Donald Trump, were charged under this 2002 law that grew out of the Enron collapse regarding people who obstruct an official proceeding. And it looks like the Supreme Court has backed the January 6th defendant. June Grasso, senior legal analyst, is still with us. June, what does this mean?
Well, it means that some defendants are going to have their cases trimmed back, and this also affects Donald Trump because he's been charged with this same crime. So it's going to affect a lot of January 6th cases. I think very few of the January 6th defendants just have this charge that they're facing. So if they've had a trial already, they'll probably still be.
And is this charge specifically against preventing approving President Biden, or is it like them breaking into Congress? Is it like looting Nancy Pelosi's desk? What is that?
Well, it's about obstructing. That's the whole question. It's about obstructing official proceeding. And this was a law that came in, as we know, post Enron. And so what the defendants were saying here is this law doesn't apply to this kind of a proceeding. This is a law about papers and disrupting papers and stuff. And so, but, the law could be, any law can be read broadly or narrowly. And it says that they said that the government must show that the defendant impaired the availability or integrity for use in an official proceeding of records, documents, objects, or other things used in an official proceeding or attempting to do so. It's 6-3 again. But what's interesting is that the three are not the three liberals. The three are two liberals, Justice Kagan and Justice Sotomayor, and conservative Justice Amy Coney Barrett. So it'll be interesting to see. And this is a case that the chief wrote the majority opinion in. And, if you look back, a lot of the most important cases, the chief decide, because the chief has the ability, if he's in the majority, to decide who will write the opinion. And so the chief decided that he'll write it himself, meaning that, he thinks it's a very important case and he wanted to handle it. And I'm trying to see what else it says.
Well, you're looking, I want to update our audience right now. The Supreme Court backs January 6 defendant curbing the use of the Enron law. This could affect President Trump as well as hundreds of January 6 cases. And this centers on the Enron rule that said that people who obstruct an official proceeding could be charged for that. This appears to then sort of put that on the sidelines and say, no, this was not a disruption of an official proceeding. We're talking something like nearly 300 defendants, including Donald Trump, were charged under this 2002 law. So we are looking at that as we go. So if I'm one of the defendants, what happens, June? Like, do I go back and say, what happens?
I don't know procedurally exactly how it works, but most likely the defendants in these cases, their attorneys will go to, maybe the Justice Department will do something wholesale and, drop all the Justice
charges.
Department will just come in and drop all the charges that have to do with this. And then, but it's going to cause a lot of hassles in that. So defendants might say, I was sentenced to, well, not many of them are serving long sentences. I was sentenced to 6 months and now this came out, so maybe I should only be sentenced to 3 because I have 2 other charges. But I mean, this is about the interpretation of this law and whether you could interpret it as meaning more than, the fact that it applies to January 6 actions, that a decision. I'm trying to just see one thing to see what they said. But in other words, they took this statute, and it was a novel use of this statute, but they were trying to find something that would fit with the way the January 6th rioters went into Congress and obstructed what was going on there. So they were trying to find a way to fit it, and this to them fit. But what the Supreme Court is saying is that, no, this is not about that kind of a proceeding. This is more about papers and documents, and that's what Enron was about. So, it's hard because I'm.
You're talking as you're reading.
I'm trying.
So
the case is going to go back to the D.C. Circuit, and then it will assess whether the indictment can still stand, the Trump indictment, in light of this new and narrower interpretation of the law. It'll be interesting to see what Justice Jackson, who is siding with the 5 conservatives here, has a concurring opinion. It'll be interesting to see why she decided to side with the conservatives. And we've seen this term that she's one of the liberal justices who has gone in different ways than the other liberal justices in different points in certain cases, and this is certainly one of them. So it's a narrow reading of this statute is what it basically is. And I think you can see today, there were all 6-3 decisions today. So, I mean, this is a court so highly divided. And, at the beginning of the term, we had justices, even Justice Amy Coney Barrett and Justice Sonia Sotomayor, and the chief loves to say this, most of the decisions are unanimous. Well, those are unanimous because they're decisions in cases that you and the rest of the public doesn't hear about. They're technical or whatever. When it comes to these hot button social issues, when it comes to this kind of a case, things involving Trump, it's 6-3. This court is so divided, and this is exactly what they don't want to show the public, that they're divided down, ideological lines for the most part.
Yeah, and June, it looks like we will see you on Monday. They're done for the day. And it looks like the Supreme Court's last opinion day will be Monday. We know what that means. Trump immunity will be coming at 10 o'clock on Monday. We will be here with June Grasso for that, senior legal analyst joining us at Bloomberg. So again, we've had a lot going on, but the latest Supreme Court ruling is that they sided with the January 6th Capitol riot defendant in a ruling that could affect hundreds of prosecutions, including the criminal case in Washington against former President Trump. It now goes back to the D.C. Circuit Court to rule on whether the indictments can still stand under this new interpretation of the Enron law that is designed to help ease official proceedings, that you cannot obstruct official proceedings. That is that Enron rule. All right, let's get more here with Caroline Fredericson, Senior Fellow at Brennan and Strategic Councilor on Democracy and Power at Open Markets Institute. Can you just walk me through what you expect to happen next?
Well, I mean, I'm just like you. I'm trying to digest what happened, but I think we're going to have a whole variety of cases that are going to be reopened for return to lower court for either dropping the charge altogether and proceeding on the other charges, or adding further evidence and qualifications to make it more pertinent to the actual connection to the destruction of evidence. And, I think that's going to be obviously challenging. There are a lot of people who've been convicted already.
Caroline, to what extent are you considering this a win for Donald Trump, a positive development?
It's really hard to say on, the little that, we know, having just glanced at the head notes to try and absorb it. But he's certainly going to make it out like it's a win, and that the Justice Department has overreached, and that it continues to overreach, and it has it goes to his story about the vendetta that has been waged against him by an overly politicized Department of Justice. So he's going to call it a win regardless of what anybody else says. Mm-hmm. To the extent that it actually affects any case against him, we'll have to see. Again, I think the Justice Department is going to reformulate these cases. It's going to try and establish in some that they have the requisite connection to the charges that are listed. And this is an interesting case because it follows on an earlier case dealing with the destruction of a fish, actually, when some fisherman was picked up for violating laws regarding the kind of size of the fish he was pulling up, and he threw back some fish, and he was charged under this law. And the question was, is a fish a tangible object under the law? And they found, in fact, in that case, that it wasn't, that it was supposed to be related to a document and so forth. So we're sort of seeing this as of a piece with that. Kagan was in dissent in both cases, here, this one and that one, the prior case. And so I think, it'll be, she's been trying to make the argument that this otherwise word in there is a broad, sweeping term that should allow anything that's connected to the obstruction of an official proceeding, that it doesn't have to be related to particularly destruction of evidence. And so, I think, will the Justice Department be able to now show that they were trying to inhibit the actual counting of the ballots and, a physical piece of evidence, a document? Maybe they will, and they may be able to, but that remains to be seen.
If they don't, or they can't, then what happens with all of these defendants, including President Trump?
Well, I mean, just remember that there were multiple charges in all of these cases, and so I don't think there are probably any of them who were prosecuted simply on this particular charge. This was, I think, an additional one that allowed them to enhance these sentences. And so I think in this case, they will be a potential lessening of the sentences. Some people will be sentenced to time served, and some people, will perhaps get off altogether because their charges are so minimal that they will be a kind of slap on the wrist. So I think it'll be seen. I mean, it'll remain to be seen. There'll be a lot of different outcomes depending on the level of engagement with President Trump. He obviously had a greater involvement in all of the different back and forth between members of his campaign and a variety of people working on thwarting the counting of ballots on January 6th. They may be able to, and Jack Smith may be able to assemble a greater amount of evidence that will continue to keep these charges more relevant for Donald Trump himself.
Can we actually zoom out, and could you talk a little bit more about the 2002 law that grew out of Enron, that's kind of at the center of this decision?
Right. Well, it was interesting in that particular situation. You had a statute that was not able to capture somebody who actually destroyed the documents and destroyed physical evidence. And instead, it went after those who were who encouraged or abetted, but it didn't actually go after the direct perpetrator. And so, what Congress tried to do is strengthen the law so that it would be broader in scope and enable the prosecution of those who'd actually been directly involved in trying to evade prosecutions. So it let the big fish, so to speak, off, and those who are less responsible could be prosecuted. So they tried to fix that, and this irony, perhaps, is that, at least according to the Supreme Court, they didn't do a very good job of it.
Yeah. Caroline, we appreciate it. Thank you for walking us through all of this. Caroline Fredericson, Senior Fellow at Brennan and Strategic Councilor on Democracy and Power at Open Markets Institute. The Supreme Court is done for the day. They're coming back on Monday, and the Supreme Court will be issuing the Trump immunity ruling on Monday around 10 a.m. In that hour, we are going to have live coverage of that. So definitely stay tuned with us for that.
You're listening to the Bloomberg Intelligence Podcast. Catch us live weekdays at 10 a.m. Eastern on Apple CarPlay and Android Auto with the Bloomberg Business app. Listen on demand wherever you get your podcasts or watch us live on YouTube.
I'm Alix alongside Emily Graffeo, who just got a nice dose of Supreme Court awesomeness on her Friday. She helps me out. Paul Sweeney is sitting on a beach off today. This is Bloomberg Intelligence. We bring you all the top news in business and finance and economics through our lens of our Bloomberg Intelligence analysts. They cover 2,000 companies and 130 industries worldwide. Let's go to one of them right now. Nathan Dean, Bloomberg Intelligence Senior Policy Analyst. Lots of stuff happening in D.C. We are keeping an eye on those Supreme Court decisions, but we cannot lose sight of the complete disaster that was yesterday and that debate between President Trump and President Biden. I think the big question today, Nathan, is what does it look like to get Biden off the ticket? Like, legally, how does that actually happen?
So it's going to have to come from the president himself. I mean, this is going to be a decision that he's going to have to make. And I think that, we'll see over the weekend as he's fundraising and meeting with advisors. But as of this morning, he was even saying to journalists that he is going to be on the ticket, and he's looking forward to a second debate in September. Now, the way it would work is that if President Biden were to decide that he's not going to run, then we go to the convention and the delegates would have to figure it out. Now, President Biden already has enough delegates to secure the nomination, but if he were to say, I'm not going to run, he could release those delegates to then vote for whoever. But ultimately, then it would become a race of who wants to be the nominee for 3 months before the election and trying to take down President Trump. It's going to be very messy. You would have Kamala Harris, the vice president. You would have a lot of governors probably thinking about it. But if this were to happen, and it were to happen soon, it's going to be something that we haven't seen since Lyndon Johnson in 1968.
Nathan, how soon must a decision be made?
Good question.
Almost July. Biden doesn't seem to have a lot of time here.
No, but he does have the advantage that the Democrats are going second in terms of the convention. So the Republicans are meeting July 15th. The Democrats aren't meeting until August. So really before the convention, there's a lot of bit of time in terms of at least the logistics of getting on the ballot. If this were to happen after the election, essentially Democrats would have to go to the polls and vote for Joe Biden, knowing that they would get somebody else. But if President Biden were to decide tomorrow that he's decided he's not going to run, you're going to see a scramble amongst the Democratic Party to try and figure out, okay, is Kamala Harris the next nominee? She isn't polling all that well against President Trump on a one-on-one race. Is Governor Newsom, Governor Pritzker, Governor Whitmer, the governors, I think, would be able to put their hands up there and say, we're interested. So you would almost have like this, reality TV show, if you will.
Yeah, be like a total free-for-all.
Exactly.
Yeah.
And then ultimately it comes down to a vote in Chicago, which, the last time, Chicago obviously doesn't have the best reputation when it comes to Democratic conventions and open conventions, but, it would be quite a show in August.
Hey, Nathan, what do you think is realistically going to happen?
So look, this decision is going to come from President Biden and President Biden himself. I mean,
Sure.
It is extremely difficult for a politician, Republican or Democrat, who has served their entire life and is used to being a fighter, to then say, you know what, I'm going to take a step back and it's time for me to move on. And so, we've seen this with a lot of other politicians, both in Congress and, the executive branch. Now, I think it comes down to two things. One, if President Biden believes that last night was just because of a cold and that he can then change the narrative in the next few months, he's going to stay in. If there's something more serious that President Biden begins to believe that there is something that, that this is an issue, then I think eventually he may say, we're going to step out.
All right, Nathan, we got to leave it there. Thank you so much for that. Nathan Dean, Bloomberg Intelligence Senior Policy Analyst.
You're listening to the Bloomberg Intelligence Podcast. Catch us live weekdays at 10 a.m. Eastern on Apple CarPlay and Android Auto with the Bloomberg Business app. You can also listen live on Amazon Alexa from our flagship New York station. Just say, Alexa, play Bloomberg 1130.
We do want to keep you updated on the Supreme Court. We did get one ruling that's coming out. The U.S. Supreme Court reinstated an Oregon city's law banning public camping. This is its first ruling on homelessness in about 4 decades. We're going to get you much more on this with June Grasso in just a moment. Let's go back to Nike and just the level of the stock drop that we're seeing here. Poonam Goyal, Senior U.S. E-commerce and Retail Analyst at Bloomberg Intelligence, joins us now. Poonam, I guess, what would a turnaround for this company at this point look like, and how long would something like that take?
Sure. So I think it's all product dependent. They have introduced new product as of recent, and that product has done well, especially in their Air franchise. I think it's a matter of time. Nike really took its foot off the pedal when it came to innovation since the pandemic, and now it's just starting to push the pedal harder. It won't happen overnight. We think it's going to take at least 6 to 12 months. So this year, their fiscal 2025 will be a wash year. It will be down. And I think we will have to look past that in another 6 months. But I do think that Nike has the ability to bring back innovation. It is the largest athleisure brand. And while it has lost share to Hoka in running and Adidas in the lifestyle category, if they can get the right product out, they can do well. Their dunks were a huge success, but they need more.
Can you talk about how much of the movement that we're seeing in Nike today has to do with company-specific news, and how much of it has to do with traders kind of telling us a signal about the consumer maybe being weaker than perhaps the numbers that we got this morning, the eco data that we got this morning suggesting?
Sure. I would say that the bulk of the move that you're seeing today is company specific. It's not the macro. When I look at the athleisure space, there's a lot of tailwinds in there, especially the sporting events. We have the Paris Olympics coming up, and there is still brand heat for sports to be outdoors that provides a benefit to these athleisure brands. So I'd say while the consumer is being picky and they're choosy, they're still spending where they want to spend. And if you have the product, they will come to you.
But nevertheless, why is it going so poorly? Like, they want to sell direct to consumer and not do the retail stores as much. But even that strategy didn't work. I mean, how do they fix a problem that has so many tentacles?
The problem is at the core. The problem is at the product. So if they can fix the product, I think the problems almost resolve in themselves. It's not that Nike has lost its brand heat. They still, in basketball, are the most preferred brand. They have the best sports players. They have the highest endorsers. It's really in lifestyle where they're struggling and they've lost share. And you could say in running too. Those are the two categories that they need to bring forward more innovation. So I think the answer to their problem is product. It's innovation. And Nike just needs to push harder, and we'll have to watch execution to see over the next 6 months if they can really deliver on what they're promising.
So Emily, wait, so you do have Nikes or you don't? It's the Adidas ones that you don't have, the Sambas you don't have.
I don't have the Sambas, but it really is incredible. I mean, I like to think that I follow sneaker trends, and the Adidas Sambas is a lifestyle sneaker that is so popular and has really driven a lot of Adidas's growth. Poonam, are you saying that Nike kind of has to come up with a product similar to that, kind of a product that everyone on the street is, I guess, obsessed with and wants to wear?
Yeah, absolutely. And they did, right? They had the Air Forces, which were a lifestyle shoe. They had their Dunks, which became a lifestyle shoe, but they need more. They need to continue to keep innovating because now they're comping those tough comparisons and they just need more innovation. So it's really, really getting the product right here.
like, how much more can you innovate a sneaker? Like, I mean, this is such a dumb question. I don't wear sneakers. I have a weird foot. I got to wear Bionics. Like, my feet are old feet. But, I mean, how hard is it to innovate a sneaker?
Well, I mean, the Samba's not really that innovative, right? I mean, I grew up wearing Sambas as a kid. So it's about just getting people comfortable and getting the trend right, getting the look right, the feel right, and being where the customer is and really bringing your brand forward with those customers. Look, Nike's still the largest activewear brand. It's still the dominant player in sneakers. And Hoka and On are very small compared to Nike. So when they grow double digits, it's a small fraction of what Nike's sales are. So I really do think that they can bring something forward and really do well if they get the product. And remember, they also have to endorse the product, right? The product can come out, but then they need athletes, they need celebrities, they need influencers to make that product develop brand heat and catch steam into the marketplace, because that's how it works. That's how products sell.
Yeah, they need Emily Graffeo to think it's cool, like her and all her buddies. She's gonna be like my cool person, like, who knows?
But I want an arch support sneaker.
You have weird feet. Emily, what is it? Oh, it's a life-changing event with your sneaker or lifestyle thing?
Lifestyle sneakers,
Not
like one
her.
that
What the
you
hell
wear.
does that mean?
Not her. She can't wear those. But like, it's just like that's what all her cool friends wear. I have plantar fasciitis. So
Like you
it's a
wear
whole
it to
different
hang out,
story.
as opposed to a running sneaker that's gonna look more like a.
John has 2 pairs of shoes, so let's just keep that in mind.
You're listening to the Bloomberg Intelligence Podcast. Catch us live weekdays at 10 a.m. Eastern on Apple CarPlay and Android Auto with the Bloomberg Business app. You can also listen live on Amazon Alexa from our flagship New York station. Just say, Alexa, play Bloomberg 1130.
All right, let's get to what's happening in the bond market. You're right. Yields have moved higher despite the fact we got that PCE that seemed to be interpreted as, okay, the Fed can cut. It's okay. Inflation is coming down. Spending and income is hanging in okay. Danielle DiMartino Booth is CEO and Chief Strategist for QI Research. Hey, what was your interpretation, Danielle, about the data and then what we're seeing in the bond market right now?
So, thanks for having me this morning. It's great to be with you again. And this is a real head scratcher for me. Unrounded 0.08% increase in the core. The Fed's year-end target is 2.8% for the core PCE. It's down to 2.6%. Same with its unemployment target for the end of the year, 4.0%. That's where the unemployment rate is right now. So it would seem to be, a green light for the Fed to cut rates here. And we had University of Michigan see an appreciable decline in inflation expectations in both the short and long term. So go figure on why bond yields are up. That's my honest answer here.
So what about when you look to the rest of the year? We're just at the halfway mark. What do you really see is going to be driving the cross-asset market action?
So, there's a real tug of war. There are a lot of good observations being made right now about the K-shaped economy, the haves and the have-nots. You see that when you get the second print for the University of Michigan and that you get terciles of income broken out. And you see that there's a lot of anxiety among the lowest income earners. We've got an institutional client at QI who was saying that a Tampa food bank has gone from 20,000 to 40,000 per month households that it's serving, that a lot of these nonprofits are just overwhelmed with the amount of demand. As we're seeing, again, the difference between 2023 and 2024 is 2023 were really white collar layoffs, 6 to 9 months of severance. And then you hear from the likes of Walgreens yesterday, up to maybe 60,000 jobs in peril there with all of those stores closing. These types of job cuts, the people who lose their jobs only get 6 to 9 weeks of severance. So it's a huge difference.
So fair enough. Okay, so if we just sort of go with yields are doing stuff, we're end of the second quarter, so things are moving, et cetera. Do you think the data that we got today can greenlight a cut from the Fed, and when do you think that could be greenlit?
I do. We have seen revisions out of the state of California that show that net job losses through the second half of 2023, the last 6 months of 23 were negative. We're going to get several revisions out of the Census Bureau for payrolls before even the July Fed meeting, and certainly a very large one in August before the September meeting. So I'm looking at September as the definitive launch date for Fed rate cuts.
Does the equity market need a rate cut in September? Because here we are, we're at all-time highs today, and we still have, yields moving a little bit higher, but I'm just wondering if we don't get that cut, maybe it's pushed out even further, maybe into 2025. Does it tank stocks, you think, or are we able to kind of stay here at these all-time highs and continue chugging along for the rest of the year?
I think the stock market does hang in there. Historically speaking, until the Fed actually cuts rates, stocks are very well behaved. It's only after the Fed actually makes that rate cut, no jawboning, no quantitative tightening or quantitative easing, but actual rate cuts that start, then you see stocks correct. Then you see stocks decline. And that's, again, historically back in the post-war era, how the script has played out.
Hey, Danielle, walk us through what you're expecting for Jobs Friday next week. So we get the PCE. It seems to be okay. The inflation story seems to be adjusting, right? That super core is coming down. The data this week was very lumpy, not great, particularly when it comes to housing. You heard Mary Daly talking about worries about growth, for example. And we had also worries about, are we actually restrictive enough? And if we're not, then that could really spur more growth issues. What reflection do you think we're going to get in the jobs number next week?
So I would be surprised just on a pure data basis if we didn't see a little bit more weakness at the margin in the jobs data. The survey week for non-farm payrolls did see an uptick in both initial and continuing claims in that survey week rising to the highest since 2021. And that is when the survey data are collected by the Bureau of Labor Statistics. So I would expect to see this weakness. Again, a lot of the layoffs we're seeing, the reason we're seeing the 4-week moving average and initial jobless claims steadily march upward over the last few months is because the people who are losing their jobs get a very short period of pay from their former employer before they're filing that initial jobless claim. We're seeing that very steadily rise this year.
So that's the macro. I want to go super micro maybe, and we don't have that much time left, Danielle, but what do you make of the volatility in these pet stocks after Roaring Kitty comes on Twitter, he posts a picture of a dog? I mean, just talk about, what does this tell you about the market that we're in, that we're still seeing? He didn't even mention Petco, and yet the stock kind of went crazy after his tweet.
So again, I think this goes back to the point that I made earlier, and that would be one that we have not seen any capitulation in this stock market. The fervor to speculate is still very much alive. What we call animal spirits, it's still out there. People are still ready to gamble on the stock market as if the pandemic just hit the shores. So it again shows you that there's a great big willingness to take risk.
Well said. Emily's quoting you right now for an article. She was very excited to ask you that question. Yeah, and then it's too much liquidity. It's a lot of cool liquidity out there, even if that upside didn't continue into today. All right, Danielle, we really appreciate Danielle DiMartino Booth, CEO and Chief Strategist for QI Research, joining us there.
This is the Bloomberg Intelligence Podcast, available on Apple, Spotify, and anywhere else you get your podcasts. Listen live each weekday, 10 a.m. to noon Eastern on Bloomberg.com, the iHeartRadio app, TuneIn, and the Bloomberg Business app. You can also watch us live every weekday on YouTube and always on the Bloomberg Terminal.